If you think your will should include everything you own and every wish you have, think again. There are certain things that just don't belong in a will, and putting them there could actually create legal headaches for your family. Today I'm going to share 8 things you should never put in your will and what to do instead, so you can make sure that your estate plan actually works the way you intend. I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm one half of the estate planning guys. I help families make smart estate planning decisions that actually work when they're needed. And today, I want to make sure that your will isn't setting your family up for unnecessary stress and complications. So let's get into the list. Number 1, property held in a trust. If you already have a trust, you don't need to list those assets in your will because the trust takes care of them. And putting them in your will can create confusion and even undo what your trust was designed to accomplish. So what do you do instead? Well, make sure that your trust is properly funded and up to date, so those assets pass smoothly to your beneficiaries without probate. But that's just the beginning, and the next one might surprise you. Number 2, retirement accounts and life insurance proceeds. Your 401k, IRA, and your life insurance, they have named beneficiaries, so they don't go through your will. And if you try to include them in your will, it won't override the beneficiary designation, and that could cause delays in distributing the funds. So what do you do instead? Well, check that your beneficiary designations are up to date and that they align with your overall estate plan, and make a plan to do that at least once a year. Maybe on your birthday, maybe, when the new year turns over, but make a plan to check your beneficiary designations once a year. And speaking of assets that don't belong in your will, jointly owned property. If you own property with someone else and it's titled as joint tenants with rights of survivorship, then it automatically transfers to the other owner when you pass away. Including it in your will can create unnecessary confusion about what you intended. So what do you do instead? Review your property titles and your ownership structures to make sure they align with your overall estate plan. Now let's talk about something a little bit different. Funeral instructions. You might assume that your will is the perfect place to put your funeral instructions, but here's a problem. Wills often aren't read. Sometimes people can't find them until days or weeks after a person's passing. And that means that your family might not even see your instructions until it's too late. How do we address that? Leave a separate written document with your funeral wishes on it and share that with a trusted family member or your executor, and they'll have that even if they don't have the will. Now, this next one could create a legal mess if you're not careful. Conditions on inheritance that aren't legally enforceable. Some people try to attach conditions to their will, like, my daughter can only inherit if she marries a doctor, or my son gets nothing unless he finishes college. But courts often won't enforce these conditions, especially if they go against public policy. So what do you do instead? Well, if you want to control how and when someone inherits, you use a trust instead of a will. And a trust allows for any legally enforceable conditions to be put in place. So let's talk about something that you might be tempted to include, but you definitely shouldn't, and that's digital assets like social media and email accounts. Your Facebook, Instagram, and email accounts don't belong in your will because they're governed by the terms of service of the companies that own them. So how do you handle that? Well, you use a digital estate plan with clear instructions and a designated person to manage your online presence. A lot of states have adopted uniform laws now that give your executor power over the digital assets, but that can conflict with what these companies have in their terms of use. So you want to make sure that you review those terms of use if your digital assets are important to you, and make sure that you have the right pieces in place. Now, let's talk about personal care decisions, and here's where things get really tricky. You don't want to put your medical wishes in your will. Your will is the place to take care of what happens after you die, not about your medical decisions. So if you think you have specific ideas about what you want with respect to life support or certain medical treatments, then you're going to want to put that in a different document. That's called an advance directive for healthcare, or a healthcare proxy, or a living will with a durable power of attorney for healthcare. And that's where you outline your medical wishes and you name the person that you want to make those decisions for you, your healthcare power of attorney or your healthcare agent. Now, this last one could put your family in a difficult situation if you're not careful, and that is naming a guardian for your minor children. Your will is where you name a permanent guardian for your child. But what if an emergency happens and the court hasn't reviewed your will? Then your kids could end up in some sort of temporary foster care situation while that legal process plays out. So what do you do instead? Use a standalone guardianship document to make sure that your wishes are clear before the will is even reviewed. So you can use a standalone designated guardianship to name someone that can take care of your child for a temporary period of time until the court process can play out. Now, a moment of seriousness here. All these mistakes can cause delays, confusion, and unnecessary legal battles for your loved ones. But the good news is they're completely avoidable if you have the right estate plan in place. A will is just one part of a good plan, but it's not the only part. Making sure that your assets are properly titled, having a trust where it's needed, and using the right legal documents for healthcare and guardianship are just as important. So, do you know if your estate plan is set up the right way? If not, I've got you covered. You can download our estate planning checklist. There's a link in the description below to our resources page. It's completely free and it will help you make sure that your plan is complete. And if you found this helpful, check out our next video. You're not going to want to miss it. I'm Mike Smith with the Estate Planning Guys.